for being.
Thanks, Deputy Speaker. I'd like to commend the speech from the member for Cooper. She's dedicated so much of her working life to eradicating worker exploitation and ensuring that there's fair treatment of workers right across this country, and she is a source of inspiration for many of us in this House. But, Deputy Speaker, I also rise today to speak in favour of the Migration Amendment Strengthening Employer Compliance Bill. Deputy Speaker, the Albanese government recognises that Australia's long-term economic prosperity cannot and should not be achieved through the exploitation of migrant workers. For those of us in this House who are committed to being good neighbours, well, this is where we can start ensuring that we are good neighbours by making changes to this incredibly troubling practice that has unfortunately grown over the last decade. And Deputy Speaker, what we know is that 1 in 6 migrants are paid below the minimum wage. 1 in 6 migrants are paid below the minimum wage. The wage that we know is the minimum for a family to potentially get by in a frugal way. Deputy Speaker, regrettably, most of these workers will be too scared to question, too scared to speak to a union, and too scared to speak out because of the potential consequences. Some will even be threatened by their employers with a phone call to the Australian Border Force. Deputy Speaker, the prevalent theft of wages among migrant workers equates to an economic race to the bottom. No one wins, our neighbours don't win. It undermines the institution of our minimum wage, and it punishes those employers, the majority of employers, that are doing the right thing. If the economic viability of your business is based on underpaying vulnerable migrant workers, then your business model is deeply flawed. Deputy Speaker, this bill amends the Migration Act 1958 with the purpose of strengthening employer compliance measures and protecting temporary migrant workers from exploitation. To support greater compliance, the bill introduces criminal offences for employers who choose to coerce temporary migrant workers into working in breach of their visa conditions and establishes a mechanism to prevent such employers from employing additional migrant workers for a period of time. It's an important consequence of particularly bad behaviour. The bill also introduces amendments designed to remove some of the disincentives for temporary migrant workers to report exploitation, where currently they may fear their visa status may be jeopardised by actually making such reports. Now, Deputy Speaker, it cannot be that in modern Australia migrant workers hardly get fair pay in Australia. As we said before, 1 in 6. So it shouldn't be that they barely get fair pay because their employers think it's okay to treat temporary visa holders differently from Australian workers. It is not only simply unfair and illegal, at the heart of it, it is unneighbourly, Deputy Speaker. But, Deputy Speaker, the Albanese government inherited an immigration and visa system in crisis. Too many tasks were placed into the too hard basket, and one of those was the exploitation of migrant workers. And this led to an unchecked rise in exploitation. And when the heat finally got too much, the previous government commissioned a task force, the Migrant Workers Task Force, back in 2016. Now, Deputy Speaker, after 3 years of listening to stakeholders, the task force made recommendations, some of which were cherry-picked and some were put into a bill that the previous government introduced, but it never seemed likely that that bill was going to make it to a vote. Deputy Speaker, it should come as no surprise that on immigration reform, like so many other areas, those opposite dropped the ball. And the immigration legacy that the Albanese government inherited included a system that prioritised temporary visas over permanent visas, changing visa rules to restrict workers' rights, and having pathways to residency removed. Deputy Speaker, the enforcement of what little regulation migrant workers had protecting them was actively rolled back. Up until now, the benefits of exploiting migrants outweighed the consequences, and bad employers have made the most out of it. As I said before, a minority still, but nonetheless having an incredible impact on our migrant neighbours. This legislation importantly changes this. One of the critical parts of tackling exploitation is the need for a functional and well-administered visa system. We know that a system with long waiting times and poor client services creates additional vulnerabilities for the community and the government. Another failure in the government's response to migrant worker exploitation. For people who've been exploited, the Migration Act has criminalised speaking out. Section 235 of the Migration Act creates a criminal offence for a visa holder to work in breach of a work-related visa condition or for an unlawful non-citizen to work at all. Although this criminal offence has not been prosecuted since it was introduced over 2 decades ago, this government understands that workers are afraid to speak out. We intend to change that, and a key element of this bill is to repeal this offence. Deputy Speaker, I'd like to discuss some of the findings and highlight the work from the Migrant Workers Task Force. One of those findings was the underpayment of migrant workers. As has been discussed in the chamber today, underpayment is a long-standing problem with significant impacts for affected individuals, the labour market and the broader community, but it's difficult to precisely quantify the prevalence and severity of the problem. Just 2 months ago, Professor Alan Fells, Chair of the Task Force, told The Australian, and I quote, "This exploitation has been a severe problem for at least 10 years. There have been huge numbers of underpaid and exploited migrant workers, and nothing was done about it." Professor Fells has also made it clear that wage exploitation of temporary migrants offends our national values of fairness. It harms not only the employees involved, but also the businesses which do the right thing. It has potential to undermine our national reputation as a place for international students to undertake their studies, and may discourage working holiday makers from filling essential gaps in the agricultural workforce. This problem has persisted for too long, and it needs concerted action to overcome it. Deputy Speaker, Professor Fells is right. This has gone on for too long, and it's disgraceful that migrant workers have had to wait until now for proper action. Deputy Speaker, the Task Force also identified that there are a number of vulnerabilities to workplace exploitation that are common among migrant workers, including limited English language skills, lack of awareness of Australian workplace laws and, as I mentioned earlier, a fear of visa cancellation, detention and removal from Australia. Additionally, peer and community or family expectations, norms within cultural groups, as well as economic settings in visa workers' home countries, can also influence their decisions regarding low-paid work. Research shows that even where migrant workers are aware of legal minimum wages, some will still accept much lower pay rates. One research article the Task Force cited was from a 2015 study of international students in Sydney that found that international students tolerate and accept lower than lawful wages, not only because the wage rates can be higher in comparison to their home countries, but also lower than lawful wages are normalised and accepted among their international student peers. This must end. Deputy Speaker, exploitation of these workers was found to take many forms, such as wage underpayment or cashback arrangements, pressure to work beyond the restrictions of a visa, upfront payment or deposit for a job, failure to provide workplace entitlements such as paid leave, superannuation, many things we take for granted, tax avoidance through the use of cash payments to workers, unpaid training, working conditions that are unsafe, unfair dismissal, misclassification of workers as independent contractors instead of employees. That sounds a bit familiar. requiring migrant workers to use and pay for substandard on-site accommodation. This problem is not isolated to one or two sectors of employment in the economy. It's more diverse than that and stretches from remote fruit picking to convenience stores in regional cities and to the global ICT multinationals in our capital cities. Deputy Speaker, this is a complex issue, but to not respond to this soundly would be giving dodgy businesses the green light to maintain the status quo. It would be the same as surrendering this issue to the too hard basket, which is not what Labor governments do. That's why there are 6 parts to the Albanese government's approach to addressing this systemic problem. Part 1 of this legislation enacts new criminal employer sanctions. New criminal and civil offences are being introduced concerning coercing people to work in breach of their visa conditions or using their visa status to exploit workers. The penalty will be up to 2 years in prison or 360 penalty units. Deputy Speaker, this will be an important deterrent to employers who think about exploiting workers due to visa conditions. By adding such strong penalties, we can disincentivise those employers actively doing the wrong thing. Part 2 of the bill prohibits employers and individuals from hiring future workers on a temporary basis, on temporary visas. These new prohibition notices will enable the Minister to declare employers and individuals to be prohibited from hiring new workers on temporary visas for a period of time. Employers and individuals will be subject to these discretionary prohibition notices when they're found to have breached migration and employment law. Triggers for prohibition will include court orders, non-compliance with employment and migration law. And where employers and individuals are subject to such notices, the Minister must publish the relevant details on the Department's website. Part 3 aligns and increases the penalties for work-related breaches. Penalties are increasing for work-based breaches to align with the maximum penalties available under the Migration Act. This is intended to better reflect the seriousness of illegal work practices and the exploitation of temporary migrant workers. This will see penalties increase from 60 units to 240 units, which is designed to send an important message to businesses thinking about exploiting migrant workers. Part 4 of this bill will enable enforceable undertakings for work-related breaches. This amendment will seek to use similar provisions under the Migration Act by the Australian Border Force. This will provide the ABF with additional tools in their enforcement approach. Deputy Speaker, the ABF asked for more tools to enforce compliance, and this bill will do that. Finally, Deputy Speaker, this legislation will empower migrant workers to speak out without fear of visa implications. Under the Migration Act, the exploitation of a worker will be able to be considered as a potential mitigating factor when visa cancellation is under consideration. This will send an important message to migrants who are on temporary visas who are worried to speak up that their visa will not be cancelled if they are being exploited. This will bolster the usage of the Assurance Protocol, a process that is used between the Fair Work Ombudsman and the Department of Home Affairs, designed to ensure when people report their employer to Fair Work that they are not penalised by the Department of Home Affairs. This bill reflects the government's strong principle that approaches to employment and migration will work side by side to address exploitation. The Fair Work Act and the Migration Act will work together to protect workers regardless of their visa status. Deputy Speaker, the Albanese government is working to address all aspects of this issue, which includes ensuring that Australia has a functioning and efficient visa processing system. Those that have suffered the most to migrant worker exploitation were ones we relied on at the height of the COVID-19 pandemic. It was visa holders who were stacking shelves, staffing hospitals, delivering essential care, or delivering food to those stuck in home quarantine. In effect, they were being good neighbours, Deputy Speaker. I thank the coordinated efforts from Ministers O'Neill, Burke and Giles, who've worked together to ensure that this issue can be addressed properly, not with a band-aid, but with legislation with a vision to end the exploitation of migrant workers so that we will be good neighbours to all our brothers and sisters across this country. I commend the bill to the House.